Hi, this is Joe from PrepAgent, and today we're going to go over some property ownership questions. You can see me here in my apartment, and it's at night, and we're ready to do this. If you have any questions, write in the chat, and also I'm going to be using questions from our website. If you want access to the website, just look in the notes below. We got a nice promotional code for you, so by all means, feel free to use it. And with that being said, let's get started. Okay, hopefully everybody can see the screen here. Okay, so right now we have our first question on the board. I'll read it out loud, I'll read the questions, and you guys answer the questions on the right-hand side. Okay, a tenant's lease has expired, but the tenant did not vacate the premise or negotiate a renewal lease. The landlord has declared that he does not want the tenant to remain in the building. This type of occupancy is referred to as an estate. Okay, the options are at sufferance, for years, from year to year, or at will. Okay, and the answer is at sufferance. So good job, all you guys who put sufferance on the side. I see a lot of you in the chat wrote sufferance. Good job. Now, what I want you guys to remember, what we're talking about here is less than freehold estates. You got freehold estates and less than freehold estates. When you got the less than freehold estates, you have your estate for years, your periodic tenancy, estate at will, and estate at sufferance. When you think of an estate at sufferance, just think the landlord is suffering, okay? I often like to call this a deadbeat tenant, somebody who stayed and has not paid what they owe. All right, next question. Generally, construction onto the property of another, like a wall, fence, building, etc., is known as what? A, estoppel, B, easement appurtenant, C, encroachment, or D, situs? What do you guys think? And the answer is encroachment. Okay, this is encroachment. And one thing I want to clarify for you guys is encroachment doesn't always have to touch the floor. For example, if you have a tree that's leaning over onto the property, even though it's not physically touching the ground, that as well is encroachment. Okay, because your property line goes all the way up to the sky above. It's not just on the ground. Okay, next question. Which of the following would be considered real property? A cell phone, diamonds which have been mined, trade fixtures, or a bearing wall? Give you guys a few minutes to answer. Okay, so you got real and personal property. It's one of the first things you learn when you start practicing for the real estate exam. You probably learned real property are things that are immovable, personal property are things that are movable. But I want to give you guys a better definition than that. Real property goes with the real estate. Personal property goes with the person, which is why usually it's movable. Not always. We'll get into some exceptions later. So when you look at the options here, you have a bearing wall. A bearing wall is something that is immovable. Bearing wall is that support structure in your house. It's the most important wall in the property. So it's about as real property could get. Okay. A trade fixture is something that goes with the trade or business, and that can be immovable. Okay, like a dentist chair is a big example. But yet it's personal property because it goes with the person. And that's a good example why I don't always like saying personal property is movable and real property is immovable. These trade fixtures are sometimes things that are immovable, but yet they're personal property because they go with a person. Okay, next question. Oh, did I forget to click the answer? My bad. There you go. Okay, which of the following would be defined as a fixture in the law? So in the chat window, I'd like to see people tell me how you know something is a fixture. There's a certain name you should remember. Does anybody know? Okay, so what we're looking for is the word Maria. Good, and that stands for method, adaptability, relationship, intention, and agreement. If you're listening to this, I want you to write that down. Method, adaptability, relationship, intention, and agreement. Okay, that's a test for a fixture. You remember that with the name Maria. Okay, let's click the answer and see what we got here. So which of the following defines fixture law? A built-in stove in a mobile home, crops after harvest, something incorporated into land, or area rugs in a home? Okay, so the answer is something incorporated into the land. By definition, that's what a fixture is. It's incorporated into the land. How do you know that it's incorporated into the land? Because of that Maria's test. Method, adaptability, relationship, intention, and agreement. Some of you guys said a built-in stove, but that's for a mobile home. Okay, so that changes it a little bit there. All right, let's get that next question. Okay, Xena granted the property to Ugrilda, but because she knew that Ugrilda had a drinking problem, she told her there was a condition. The condition was the property would be forfeited if alcohol is sold on the premise. Ugrilda would have which of the following estates? A, life estate, B, estate at sufferance, C, fee simple to feasible, or D, fee simple absolute? What do you guys think? All right, we're going to check for this answer here. And the answer is fee simple to feasible. Fee simple to feasible is type of freehold estate. Remember we talked about the less than freehold estates when we said things such as estate for years, estate at will, estate at sufferance, and periodic tenancy. You have your freehold estates where you probably hear the terms fee simple absolute, life estates, okay, and fee simple to feasible, okay? Fee simple to feasible means there's a condition of which the estate could be defeated. You guys have to know when there's a condition, that means something you could lose the property. Very often hear conditions and covenants. Covenants usually result in some financial penalty. Conditions means you could lose the property. In this question, they're saying if she drinks alcohol, she could lose the property. That's a condition. That's a fee simple to feasible estate. All right. Next question. Randolph is renting property from Tyrone. Randolph is on a month-to-month lease agreement. This past month, he did not pay his rent. Randolph's interest would be classified as estate at will, estate for years, estate at sufferance, estate of periodic tenancy. What do you guys think? Okay. So that's estate at sufferance. A lot of you guys got thrown off by that month-to-month bit, so you picked estate at periodic tenancy, which makes sense. But you got to remember this part that he did not pay his rent, okay? So the moment he did not pay his rent, it converts to estate at sufferance. Don't get thrown off by those tricky questions they ask on the exam. They threw you off, so they put that month-to-month, but once he did not pay his rent, it immediately converts to an estate at sufferance. Ah. Huh. Okay, Pedro sold Happy Land to Josh. At the time, Happy Land had a pertinent easement across Pleasantville, which was owned by Jethro. When Josh tried to use the easement, Jethro protested. Which of the following is correct? Pedro owns a dominant tenement and the easement upon it. Jethro owns the servient tenement and his consent must be obtained for Josh to use the easement. Pedro owns the easement and can give it to anyone. And a pertinent easement always passes with the property when it's sold. What do you guys think? Okay. Okay, so when something's appurtenant, that means it passes with the property. Okay? So whenever you see appurtenant, like an appurtenant easement, that means it goes with it. It is appurtenant. All right, next one. Telephone lines are examples of an easement appurtenant, a non-revocable license, a legally valid encroachment, or an easement in gross. What do you guys think? Okay, so there's different types of easements. And when you have easements, typically you have a servient and dominant tenement. The servient tenement is the one serving the purpose of the dominant. The dominant is the one who's walking over. Okay? So an easement grows special because there's no dominant tenement, meaning there's no property they're trying to get to. There's only a property being crossed. So when you have telephone lines going across a property, they're not trying to get to another property. They're just trying to cross over a property. So there's a servient tenement, no dominant tenement. Hence, it is an easement in gross. Ta-da! Okay, next question. Title held by husband and wife may include all the following forms of ownership except severalty, tenancy in common, joint tenancy, tenancy by the entireties. What do you guys think? Okay, so this one's basic vocabulary. Some of you guys saw husband and wife and you get confused, especially because in different states, they have different definitions of what it could be. Some states use community property, some states use tenancy in common, joint tenancy, some states use tenancy entireties. But none of that should matter, all right? Because if you see that word except, you should know that the one thing it cannot be, under no circumstances, severalty, because severalty means sole ownership, okay? So when you see a husband and wife, it doesn't matter if the other options are tenancy common, joint tenancy, community property, ishkabibble, or figglefoggle, whatever it is. The moment you see severalty, that should be the answer, because that means sole ownership. And if it's husband and wife, it cannot be sole ownership. Okay, does everybody understand that? So when they see husband and wife, they're saying, what about my state? What's the rule in the other state? It doesn't matter, because that word except is at the end. Okay. Which of the following would be the best and most complete definition of the term encumbrance? Okay, the degree, quantity, nature, and extent of interest which a person has in real property. Any action taken relative to property or then acquiring or transferring title, the use of property by a debtor to offer a creditor security for a debt, or anything which affects or limits the fee simple title to property. What do you guys think? Okay, so encumbrance. When you feel encumbered, you are limited. I use the example, if you sleep at somebody's house, they have too many blankets and too many pillows, it's hard to sleep because you feel encumbered. You can't move around, you can't function, you're encumbered. That little kid who goes to school for the first time and has the enormous backpack with all the books and he weighs them down. He is encumbered because he can't move, okay? So the word encumbered, it's not just a real estate term, it's basic vocabulary. And I want some of you guys to understand that. A lot of you guys get so intimidated by the vocabulary on this exam that you forget this isn't real estate vocabulary. It's vocabulary in your everyday life, just being applied to real estate. And this is a perfect example of that. Okay, so an encumbrance is anything that limits you. Mary owns a parcel of land and is trying to show that exceptional circumstances exist which justify using the land in a way which is prohibited by current zoning laws. Her intended use would not be detrimental to the public. She would probably petition the Planning Commission for a redevelopment permit, rezoning agreement, building permit, or variance. What do you guys think? All right. Answer is variance. Okay, the key part about a variance is it's an exception to the rule that does not affect the rest of the community. Okay, that's the big part of it. It's when you're asking for an exception that will not affect the other people around you. Okay? Okay, next one. A real estate broker may have difficulty with personal property because its ownership rights and identification may be difficult to determine. This is because personal property can be alienated, hypothecated, and become real property, or just be alienated, just become real property, or just be hypothecated. What do you guys think? Some of you are going to go with that default. I like the long answer. Always go with the long answer. Long answers are better. And honestly, sometimes you'll be right. And this time you would be. Okay, personal property can be alienated, which means it could be given away. Hypothecated, which means you could take a loan against it. And it can become real property. And what do we call that? I want to see people write in the comments on the side. What do we call that when personal property becomes real property? We went over a word about that. We brought up a certain name that was part of a famous song by Blondie. What's that called when personal property becomes real property? Yep, that's Maria. That's Maria. Okay. Method, adaptability, relationship, intention, and agreement. That was a fixture. Good. Excellent. Maria, I haven't seen her. Anybody know that song? Anybody who admits that song admits their age, that they were a child of the late 70s. Okay, deed restrictions on a subdivision said the lot must contain a minimum of 15,000 square feet. The zoning restrictions said that the lot must contain a minimum of 10,000 square feet. Which would prevail? The one recorded first, the one recorded last, the deed restrictions, or the zoning restrictions? This is a tricky one. What do you guys think? And the answer here would be the deed restrictions. And the reason is because you go with the ones more restrictive. The deed restrictions require 15,000 square feet. The zoning required 10. So obviously, if the zone required 10 and you had 15, you'd be fine. You'd be okay. So things like this, you always go with the more restrictive. Okay, so it wasn't a matter of first or last or deed or zoning. It was which was the more restrictive. Ooh, somebody just wrote, I always sing that song. It's a good song. Why wouldn't you always sing it? It's catchy. It's Wonderful, and I love it. Okay, and I bet I'm not the only one who likes it. Okay, an instrument which usually transfers possession of real property but does not transfer ownership is an easement, a sublease, a security agreement, or a mortgage. What do you guys think? An instrument which usually transfers possession of real property but does not transfer ownership is easement, sublease, security agreement, or a mortgage. What do you guys think? Okay, and the answer would be Am I there now?
Yep, you're still on fire. Not showing anything. Like an eye.
Am I back on the Oh, sorry about the little snafu there, guys. Everybody should be able to see me now. All right, we're good? Yay, I'm back. Sorry about that, guys. Remember, this is our second time doing this. We're still in the trial phase. We're working out the glitches, but I hope you guys like it. Which brings me to my next point. If you guys get any feedback on what we're doing here, please send us a message. We really want to do this on a regular basis and have you guys participate. And also, while I'm talking about it, if you want these questions, remember, go to our comments below. Okay. If a person leased a store for only 6 months, that person would have an A, estate at will, B, estate at sufferance, C, estate from period to period, or D, estate for years. What do you guys think? Okay, remember, estate for years is for a specific period of time. If you see 2 dates, like April 1st to June 8th, that's an estate for years. Or if you see 6 months, 3 weeks, 4 months, whatever it is, it's a designated period of time, all right? That's an estate for years, okay? And remember, this is a type of less than freehold estate. Okay, in tenants in common, there's always unity of time, interest, possession, or title. What do you guys think? Time, interest, possession, or title. Lots of people get this one wrong, and I'll explain why in a second. Looks like not in this group. It looks like a lot of people here are getting this right. Good job. And the answer is C. The reason a lot of people get it wrong because they think, well, doesn't it have time, title, interest, and possession? Well, that is because they're thinking of a joint tenancy. A joint tenancy is time, title, interest, and possession. A tenancy in common has only interest of possession. Okay? These things are types of concurrent ownership. So here's my question for you guys. These are types of concurrent ownership, joint tenancy and tenancy in common. Okay? What do you call the type of ownership when you're alone, when you are solo? We went through this before. What do you call that? And that is severalty. Good. Excellent. So I saw in the comments that some people are nervous about this test. I want people to realize that we're all nervous when we take this test. Most people who take this exam are not always the best student. They can be great business people, super smart people, super great salespeople. But, you know, a lot of us have been in school for years and years and years. And I also don't want people to be afraid of failing the test. After you pass, nobody's going to know if you failed once, twice, or 3 times. They're just going to know you had your license. That's it. It's like that old joke. What do they call the guy graduate last from dental school? They call him a dentist. Same thing here. If you fail once, twice, or 3 times, as long as you pass, that's all people care about. So I guess my point is, no matter what the obstacle is or how long it takes you to get this done, keep at it. Because remember, your end goal here is not to pass a test. Your end goal is to sell real estate. Okay? And that's what's most important. And once you get past this test, it may take you a little longer to do it. That's fine. But you may sell a house much quicker than the person who passed the test the first time. And isn't that what this is all about? Not really passing the test. So just keep at it no matter what your struggle is, no matter what you're dealing with. All right, don't give up on it. And remember, the test is not the end goal. It's just an obstacle you got to get by to make that money by selling the house of the dreams. Hey, let's go on to another one. Which of the following would be defined as a fixture in the law? We went over this before. I want everybody to get this right. Let's do it really quick. 3, 2, 1. What do you guys think? And you should be getting something incorporated into land. Exactly. Perfect. Great job. In determining whether an item is a fixture, which of the following would not be considered? Value of the item, method of attachment, intention of the parties where the fixture was installed, adaptation to the real estate. What do you guys think? Remember, Maria, method, adaptability, relation, intention, and agreement. There's no V in Maria, so there's no value, and there's no C for cost or price or P for price, anything like that. Good. Okay, I expect everybody to get this one right. Mr. Smith owns real property in severalty. This term is used to legally describe ownership by co-tenant, remainder, an individual, or several tenants in common. What do you guys think? Individual. Good. Who could tell me here the 2 types of concurrent estate that could come up on your real estate exam? There are 2 of them. What do you guys think? What are the 2 types of concurrent estates? All right, you got joint tenancy and tenancy in common. Double or nothing for all you guys have been studying. Which one of those, out of joint tenancy and tenancy in common, have the right of survivorship? What do you guys think? Out of joint tenancy and tenancy in common, which one has the right of survivorship? Okay, I see a lot of you answering joint tenancy. Good job. One more question. Out of joint tenancy and tenancy in common, which one would you take with a corporation? What do you guys think? Out of joint tenancy and tenancy in common, which would you take with a corporation? And the answer is tenancy in common. Great job. And the reason is because joint tenancy has right of survivorship. You can't have right of survivorship with something that's not alive. Corporations are not a living thing. So therefore, you would take it as a tenant in common. In other words, you could take property as joint tenants with Joe, all right, because we have the right of survivorship. But you cannot take property as a joint tenancy with PrepAgent because that's the company. Okay? Does that make sense? I hope it does. You got that right. You showed a really good understanding. We're going to do one more question. Let's hope everybody gets this right. Let me find a really good one here. So this relates to what we just spoke about. Leslie and Vivian bought a store building and took title as joint tenants. Vivian died testate. Leslie now owns the store. Is it as a tenant in common with Vivian's heirs, in trust, in severalty, as joint tenants with the right of survivorship? What do you guys think? It's a little trickier, and this goes back to what we just spoke about. In severalty, because Leslie now owns the store outright because it was joint tenants. It doesn't matter if Vivian died testate and had a will for her family, okay? Because she doesn't have that right because Leslie has the right of survivorship, okay? So now Leslie owns it alone in severalty, okay? For those of you who got confused, look at it again. The two of them owned a store together. They had title as joint tenants. So the other has the right of survivorship. Vivian died testate, which means she had a will. But the trick to this is that's irrelevant because her heirs don't have rights to the property because it's Leslie's rights to the property because it is joint tenancy. Okay? Hopefully that makes sense. All right. Okay, well, that was that for today. I hope you guys liked what we did there. And if you have any comments or questions, please let us know, and we'll see what we could do. Okay, so good night, guys, and make sure you look into the show notes below, and you can see a discount code for the questions if you want to do them on PrepAgent.com. And I hope you have a good night. Be sure to find us on Facebook, and if you have more questions, please participate in our Facebook group, the PrepAgent Facebook group, which has people just like you having conversations about the real estate exam. Thanks again. Talk to you soon. Ooh, Starbucks. Somebody wrote Starbucks. I love Starbucks. Okay. Good night, guys.